Welcome to the Turner African American Service Council, called TASC, presentation in our series that we are calling the African American Journey Toward Equality, Past, Present, and Future. Our topic for today's presentation is the fight for voting rights then and now. And we thank all of you who are present and those of you who are streaming for joining us in today's presentation. And we're going to ask at this time and invite Reverend Mashad Evans, the pastor here at Bethel AME Church, to come forward and give us an invocation and words on the occasion.
Good afternoon, everyone. It's a privilege and pleasure to be with you, and for those who are joining us streaming, we are glad to have this opportunity to share with you. Let us pray. Most gracious God, for this beautiful day, for this beautiful hour, and for this very moment, we give you thanks and we give you praise. For this awesome organization of men and women who come together faithfully to discuss issues of our community. God, we give you thanks and we give you praise. We pray, oh God, that your spirit would abide with us here and that you would do what your power desires to be done in this place. Have your way in us and with us, and whatever it is you choose to do and however you choose to do it, we'll be quick and careful to say that Jesus did it. For it's in Jesus' name we pray and ask it all. Amen. Our brothers and sisters, this week is a historic week. As many of us know, this coming Tuesday, we have primary elections, both for local, county, and state government. However, in 1965, August of 1965, Lyndon Johnson signed the Voting Rights Act. Even though African American men had received the right to vote with the 15th Amendment, and African American women, like women throughout the United States, did receive the right to vote in the 1920s. It was only until 1965 that it became constitutionally codified for all Americans to have the right to vote. The challenge is in 2022, we're still dealing with some of the issues of generations past. That when it comes to disenfranchisement of voters, especially African American voters, that's something we wrestle with on a very regular basis. Whether that is voter suppression, whether that is closing of voting polls, whether that is changing ways in which absentee ballots are received, it's problematic, and it's something that we still have to work and strive and struggle in this day and age. And so I'm glad we're having this discussion. I'm glad for those of us who are joining us online, especially coming into this election season. And I don't know about you, but it seems to me that the politics in our nation are more divided and divisive than they have been in years past. And so conversations like these help to bring healing, help to bring focus, help to keep us grounded. So I'm excited about the discussion. I'm excited about the questions that will be raised. I look forward to where we will move as a result of our time together.
Mr. Evans, we just want to thank you also just for always being so generous and open to us coming to use your facility. You and your congregation are always so generous and loving and welcoming, and we want to take this opportunity to say thank you to all of you. At our MLK Day presentation in January, we stated that our theme for 2022 is the African American journey toward equality, past, present, and future. We remind you again that some of TASK's mission is to serve as a liaison between the community and local healthcare providers by creating partnerships to increase and enhance access to wellness, health, education, and health care for diverse, underserved, and vulnerable seniors of color. Our vision, we envision a community in which underserved older adults of color can experience and improve quality of health care and achieve an optimal quality of life. With today's presentation, we hope to reiterate the importance of fighting for our voting rights, as we know every vote counts. And these are the names of our task members. Faye Askew King, who is our chairperson, Walter Blackwell, Gloria Edwards, Jennifer Howard, Edna Jackson Gray, Gail Jackson, Elsie Lewis, Daniel Lynn, myself, and Joetta Mile, Leo McAbee, Tom Myree, David Tarver, and Jason Page, who has joined TASK as a paid staff member whose title is Community Outreach Associate Supervisor. And unfortunately, Jason is absent today due to illness, but he has already proven to be an outstanding asset to our task committee, and we certainly hope that he will feel better soon. And at this time, I'm just happy and joyful to introduce our speaker for this afternoon, because he's a dear friend of mine. And he's going to come and talk about voting. I'm going to read his resume. And after he's finished, Faye Askew King is going to come forward so that we can have some questions and answers and some dialogue between us before we end the afternoon. Ronald C. Woods is a professor emeritus of Africology and African American Studies at Eastern Michigan University, and a lecturer in the Department of Afro-American and African Studies at the University of Michigan. He served as the Michael O. Sawyer Visiting Professor of Constitutional Law and Politics at the Maxwell School of Citizenship and Public Affairs at Syracuse University. He holds a BA in History from Wittenberg University, an MA in History from the University of Michigan, and a JD also from the University of Michigan. Before launching his career in higher education, Professor Woods was a poverty law attorney in Cincinnati, Ohio, and a founding member of the Black Lawyers Association of Cincinnati. Professor Woods consults widely in the private and public sector and regularly conducts professional development workshops on race, law, and policy. He has a wide record of civic involvement through service on numerous boards and engagement with youth and community transformation initiatives. His life work has been called and cited in the United States Congressional Record and by the state of Michigan. He is a longtime member of Second Baptist Church of Ann Arbor, and Professor Woods has been married for over 50 years to former Ann Arbor City Council person Wendy Woods. They are the proud parents of 5 children and grandparents of 10 grandchildren. The driving theme of Professor Woods' career is that our national search for a more perfect union calls upon us to know our history more profoundly than we do. And I just want to tell Professor Woods that I love that he loves history, because it's always a joy to hear him. Thank you.
Are we on? Thank you very much, everyone. Thank you to Faye Askew King, Audrey Lucas, the other members of our Turner African American Services Council. You've done good work for many, many years, extraordinary work for many, many years, and I do appreciate that. I surely also appreciate the foundation and the spiritual ushering in that Reverend Evans has given us, and the historical rooting that he always provides. It's really a joy just to talk with him about a variety of things, because he roots it in something more than the present space in which we operate. And thank you as well to our technical staff for what you do every day in many, many venues. As a representative of those across this country, I want to thank you very much for that. Indeed, as Reverend Evans has said, the work that we're looking at right now on this day, at this moment in the afternoon, is part of a long journey, a long challenge, and that seems never to quit in terms of the issues that it presents for us. I would like to come to you this afternoon around the topic, the right to vote, a historical review and a status update amid perplexing times. We're going to be coming back to that theme of perplexing times. One reason why I talked about this theme of perplexing times in the summer of 2022 is that we always find ourselves facing a challenge of some sort. Many of those challenges are anticipated, they are understood. We may not be happy with them, but we know that these kinds of things dot the universe of our lives. And then there are those challenges which are perplexing, the ones that don't seem to make any sense, the ones that you say really shouldn't be here, but that sit right in our living room in a very big way. And so I do want to talk today about this era that we find ourselves in, that's sort of defined by things that are both challenging and in some ways perplexing. We, of course, note our global pandemic, the mega climate changes of major proportions that we cannot deny just as we look out, feel, hear news, experience it ourselves. We live in a universe right now where we do have a persistence of a global expansion of wealth disparity. In many ways, this wealth disparity was given a major boost by the circumstances that brought African descent persons into this country. Of course, it is not only the 1619 Project that talks about the implications long-term for chattel slavery in this country, but for the building up of economic prowess in Europe that it later extends around the world. Unfortunately, the breakdown between nations of great wealth and those without does still reflect a color variable set into motion with the enslavement of Black folk in this country. We see transitions in the post-World War II global security order. The Ukrainian war has given us a new understanding that a world that held together very finely, that is, a very thinly, I should say, fine in that order, seems to be challenged in major ways. And the question mark always is, where will it go? We do see a resurgence of totalitarianism and extremism that is both international, global, and domestic. January the 6th of 2021 is perhaps the most glaring and in-your-face example of that extremism and that racial dynamic that often does accompany it. And so we find ourselves not only in challenging, but in perplexing times as it comes to the matter of race. And we can just reference here the fact that even though our Constitution, our founding documents, as Dr. King would remind us, use the language of equality, equal opportunity, freedom for all, justice, etc., that, as he put it 100 years later, as he spoke August the 28th of 63, we still are not free. But we have gone through some major transformations that have brought us to a point where chattel slavery does end. We'll speak about that very briefly in a moment. We have gone through a major period of what some have called the first Reconstruction. We have gone through that nadir of segregation, racial violence, and extremism. We have been able to come to a moment in time in the mid-20th century that we refer to as the Civil Rights Movement, Black Power, and Black Empowerment Movement. We've done major things, but the last several decades have made it very clear that the problem has not been eliminated. And as has been demonstrated for nearly now 46 years, since the National Urban League, a organization founded in 1911, began to issue its State of Black America. Once again, we see that there is an intractable, or I might say seemingly intractable problem of race and inequality in America. It is underscored not only by the report itself, but by its annual Equality Index. And as we know, we entered a moment a couple of years ago where there was a upsurge in hope around the 21st century era of what many called racial reconciliation, quite tragically brought into being by the death of George Floyd, but it caused many to have personal kitchen table conversations with themselves, their hearts, their souls, their families, and their communities about what the tragedy of that event that played itself out for all of us to see in slow motion time for over 9 minutes meant about where we are in this society. And it challenged many of us to begin thinking that we might have read Dr. King's message of the 1960s far too superficially. He was not heralding the immediate onset of the beloved community at that point, but was challenging us as a nation to realize what was before us if we were to do something about it, and to recognize that the tentacles of segregation and racial oppression are far deeper and much tighter in our society than we ever would have anticipated. But then, despite those hopes of an era of racial reckoning that is coming to grips with where we are, that resistance of the past has been repackaged in 21st century garb. And it reflects that the dynamics of our past have simply come back to us in many, many ways. Many will use the phrase Jim Crow number 2, Jim Crow number 2.0, James Crow II, etc. We're here this afternoon to discuss voting rights as a part of a larger challenge of racial hierarchy, a kind of Gordian knot, a knot that you just simply can't separate quite easily, strands you can't easily pull apart. It's a Gordian knot of hierarchy and inequality in America, and it's an issue that does permeate every aspect of our lives. The act of voting is uniquely one that can alter the impact of racial hierarchy across the terrain of American life and culture. The act of voting is that pivotal. It was referred to by Lyndon Baines Johnson when he signed the Civil Rights or the Voting Rights Act of 1965. It has been spoken to in many, many ways. And it's one that our large community, and surely the African American community, wants to appreciate much more deeply than we do. We are on the doorsteps of the August 2nd primary, and we know what the percentages of primary votes typically is. We are in the teens, at max and at max into the 20s, and sometimes in the single digits. But we must think that the act of voting alone determines who sits at the levels of power in our society. It determines the procedures that govern the decision-making arena, and it determines the public policy outcomes that determine our prospects for growth, for progress, and for transformation. Right now, the debate that we have been having over the last maybe less than a decade, and I'll sort of root that in, fill this in later, from Shelby versus Holder, 2013, that struck down some of the major portions of the Civil Rights Act, Voting Rights Act of 65. Since that time, we have been having a renewed debate about voting access, voting integrity, voting suppression. People have used what terms suits their ideological outlook on it. But this does highlight a cyclical pattern in our quest for a more perfect union. Ever since the ratification in 1870 of the 15th Amendment that indicated that no one could be denied the right to vote on account of rights, race, or previous condition of servitude, the time since then has been a tug of war, a perpetual kind of tug of war between progress and retreat. In our time this afternoon, I wanted to survey briefly the issue of voting rights and take some stock of the terrain today and begin to talk about, answer questions, and look to the next steps. As we mentioned before, and as we know from our history, we have a conflicted origin in the United States. And that conflicted origin is embedded within our Constitution. And there are implications of what happened in 1787 for where we are right now in the issues that essentially, in many areas, have to do with the worthiness of the African American to vote. We can talk about it in various other ways, in various other garbs, etc. But at a bottom point, many of the issues that we see unfolding in many states just have to do with the fact that there is a statement that shouts loudly, your vote simply isn't needed, does not count. The origins of that go deeply back, and I would just reference here, for many of you who may not have seen it, and for those of you who have, an extraordinary chapter, an allegorical chapter in a book by the now late Derek Bell, Harvard Law professor, and a progenitor of the critical race theory norm that is so much debated today, but only debated because there is such a profound misconstruing of what it is. In that original Constitution, we know that there were these three critical provisions, 3/5 clause, slave importation clause, fugitive slave clause. Yes, these things did specific things, but they also embedded in the American psyche the idea of a fractional person with limited, if no capacity, one who could be bought and sold, and one who could be reclaimed as property if one veered away. We won't get into it now, but it's part of that Constitution. We've got this big debate that's always been there about federalism. When can the federal government step in? When does the state have a prerogative? Who can determine voting norms? who can determine slavery, who can determine segregation in schools and things of that nature. The case that really we all know from name, that really sort of highlights this, comes some 60 to 70 years after this Constitution is put into being. It's a case that involved Dred Scott in his effort to sue in a federal court for damages for having been treated like a slave. But to do so, he had to be deemed to be a citizen. The court ultimately, in a very large tome that's just about the size that I have, or maybe 2.5 inches, if you put all of the pages together, renders some decisions that strike deep in the lexicon of Supreme Court history. The Negro has no rights that a white is bound to respect. The Negro is a being of an inferior order. And the Negro is altogether unfit to be deemed a citizen. With that idea, there was underscored in the mindset of so many that the Negro is here for purposes of labor, but never for purposes of being a part of the citizenry of this country. But of course, we soon enter into a United States Civil War. As we know, that war was not a battle of good versus evil, that is a North crusading North against the South to end slavery. Slavery surely was tied up in that in major ways. It ultimately is cast as a war to quell the effort of Confederate states to rebel, because those states said that there is simply too much interference in what is essentially a state prerogative. And while the issue of freedom for slaves was not a core item as this war began, there was what we call a convergence of interest that ultimately elevates the freedom of Black folk into a war that does result. And when I say a convergence of interest, while there may not have been many who would have wanted the Negro to sit next to him or her, there were many who felt that slavery had run its course as a cash cow for the American economy. They did not love the Negro by any means, but slavery, they said, is simply dampening what we are able to do. And there were others who said we need to free the Negro in order to put a dent in the Confederate war effort. And having seen that the Negro now can be free, perhaps we can utilize that Negro's ability to vote. But this convergence of interest leads us then into a national debate. And that national debate results in a 13th, 14th, and 15th Amendment. The one that we will focus upon is the 15th Amendment, ratified in 1870. And as Reverend Evans used as a reference point, we know it says that the right of citizens to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. The matter of women voting was a hotly debated question by both Black women and white women. How can this nation consider admitting Black men to vote when we as white women cannot enter in as well? How can the one who has labored next to me, who has been beaten as I have been beaten, walk into the voting booth before I do? These issues were there. They were very heavily debated and even made their way back into the election in which Hillary Clinton ran for 2016. But we do end up with a 15th Amendment that bans the ability to vote based upon color. And quite importantly, it gives Congress the right to enforce that by appropriate legislation. I know that's a big technical, but it is the thing that underlies the Voting Rights Act and all of the efforts that are being undertaken in that regard. And so we come away with the 15th Amendment that is reinforced by several civil rights acts, noted here 66, 67, 1870, 71, and 1875. The Voting Rights Act of 1965 was not the first legislative effort to buttress the right to vote. They were embedded into these enforcement acts, if you will, in that several 5 to 7 years after the various pieces of civil rights legislation. They give us what is essentially the first voting rights protection. There is a bump, and I'll refer to the fact of a growth in Black electoral engagement. But there's a bump, something called the Hayes-Tilden election of 1876. Up to this point, by virtue of many of the developments in our country, the federal government had been involved in monitoring matters of race between blacks and whites. It had been involved in putting itself into southern states, etc. It had been involved as a protector of the guarantees that had been made as a result of a very disputed election. And as we look at the history and listen to the discussions today, out of that disputed election in 1876, as there was debates about who are the actual electors, the state of Florida played a central role in this. Ultimately, there was no way to resolve it, and so thus it was thrown into the House of Representatives. The Republican Hayes bargained with Southern congresspersons. He said, if you vote to elect me, I will remove federal troops from the South. That is what many consider to be not only the symbolic, but the actual ending of Reconstruction, because with the removal of that break stop, then it became literally open season on African Americans, as there was no longer a channel of safety or protection. During that period of time, though, we knew that there was a great surge in the African American involvement in electoral politics. And here you have a picture, many of you will have seen this, of the first colored senator and the first colored representatives in the House of Congress. So blacks in these legislatures were very active. They were very progressive. Don't think of the way that the term has taken on meaning today, but they looked beyond where the simple items of the day were and said that we must think of ways in which we as legislators, having come through the journey and socialization that we have, can begin to look at the crises of the South and our country and be very progressive and proactive about what to do. That took place most notably in the field of education, and it wasn't limited to African Americans. Many of the provisions that were passed by this cohort of legislators were ones that did redound to the benefit of other marginalized groups in areas of education and the franchise. White males, white families in particular, were benefited. But this was a thrust that was viewed as very threatening to many other whites, and thus the pushback against blacks in electoral positions. That pushback was highlighted by such things as the white primary, poll taxes. I won't go into those, but they all operated discriminatorily to the detriment of African Americans. The white primary, for instance, as it indicates, simply said that whites only may vote in the primary. You as Negroes can vote in the final runoff or in the final elections, but we as whites will determine who the candidates are in a state such as Texas, where at that time, don't think 2022, think 1890, 1900, where Democratic power was virtually supreme. So whoever arrives out of that primary is a candidate who will likely prevail. White primaries, poll taxes, literacy tax, grandfather clauses, but the big one, of course, would be racial terrorism. All dominate. This is a story of one of the major events of the latter part of the 19th century Colfax massacre that pushed back strongly upon Black involvement in electoral politics. Over the course of the 20th century, several cases would come into being that would push back on this. Most notably, Gwynn versus the United States would eliminate the grandfather clause, and the white primary would be declared unconstitutional. That ultimately would bring us to the Voting Rights Act of '65 and the Supreme Court case that does uphold that as a ability to bring all of the country in order on voting rights. But coming into that, the activism of African Americans was very prominent. Again, these are some names with which you will be familiar. You can take questions as you might have them, but the killing, assassination of Harriet and Harry T. Moore, who had been actively involved in voter registration on Christmas Day, early in the morning, 1951, when a bomb was put underneath their bedroom and it blows up. Medgar Evers killed in June of '63 in his driveway, Jackson, Mississippi. Fannie Lou Hamer, the former sharecropper who had been beaten and jailed for her aggressive work in the area of voting rights, makes an appearance with the Mississippi Freedom Democratic Party delegation. And though that delegation does not prevail in its effort to be seated over the all-white Mississippi Democratic Party delegation, it began to move the doors open. We have the tragic death of Goodman, Cheney, and Schwerner in Mississippi. Selma to Montgomery March we'll mention in just a minute. And during that march, the tragic beating, as we know, of John Lewis, congressman, and in 1965, in that same march, we have the deaths of three quite critical civil rights martyrs. Jimmy Lee Jackson, who actually dies before the march when he undertakes to defend his mother against an onslaught from whites. James Reeb, a white pastor who was there to take part in the march and who veered along with another friend in the evening into a white area, not appreciating, I guess, significantly enough that his whiteness would not bar him from the racial animosity of those who knew that he was associated. And then Viola Liuzzo, our Detroit mother and housewife, who goes down to assist the march and is viciously gunned down by the Klan. These are all things that add to the element of agitation around the march and then around voting rights. And then we find that the act itself is signed August of 1965 by Lyndon Baines Johnson. And he makes a prediction at that time that has surely come true, that in the signing of this act and in the support for so many other pieces of civil rights legislation, the white Democratic Party in the South was basically going to dissolve, flee, and become associated with the Republican Party, because the party was being associated in the minds of too many Southerners who did not wish to think of it in that way as a pro-Black party. So that if we look at the political calendar today and talk about blue and red, the South was solid blue in the early 1960s. Today, we know that the South is red with some purple here and there. And for those of you whose politics are demographic or democratic, you know you push for those areas where these kinds of debates and elections will be taking place. But the Voting Rights Act, it forbade certain forms of voter qualification requirements, any longer literacy tests. Quite significantly, it established a formula for determining what jurisdictions prior to the passage of this act had been engaged in systemic patterns of voting discrimination. It realized that one of the challenges of voting access for Blacks was the large number of subterfuges, the runarounds, the circumventions that the South used it could not technically say anymore, Negroes cannot vote, but it could use a variety of mechanisms. And so the Congress appreciated that at this point, and it said, if we are going to stem the onslaught or the resistance that blacks have, or that is visited upon blacks to their voting, we've got to up the game on this. What we're going to do is to identify those states that are bad actors in this regard. We're going to do that by looking at the data and simply saying that if your voting percentages fall under a certain point for the eligible black population in terms of voting, you will be deemed a covered jurisdiction. And by being deemed a covered jurisdiction, you will have to submit either to a federal district court where you reside or where your state is, or to the Department of Justice, your plan for changing your voting scheme. If you want to change the times that the polls open, send it to the Department of Justice or a federal district court. If you want to change voting procedures for registration, send it. We want to see, is there a hidden agenda to what facially and racially is neutral? This worked wonders in eliminating most, or I'll just say many, to be more, to avoid it, many of the suppression laws or voter integrity, as you might look at it, that we see today. But it said to do that, we do this pre-clearance because we want to assess the lawfulness or the unlawfulness of your proposed changes. And this was captured in what we know of as sections 4 and 5 of the Voting Rights Act. If you look at any graph of voting in the immediate years after the Voting Rights Act, you see that the enormous jump from single digits to multiple digits in two numeral digits is present. The pre-clearance provision of 65, as it was called, however, was subject to, please eliminate that 2626, a sunset provision. Because Congress realized that for us to tell a state or a jurisdiction within a state, and by the way, all of these jurisdictions were not simply Southern. Some were in California, some were in New York. For us to tell, for the federal government to tell a jurisdiction in Georgia, South Carolina, Virginia, etc., you've got to approve it with us. They realized that there was going to be a perceived, as it was a imposition on the sovereignty of the state, but it was an imposition that the federal government and the Congress said, and ultimately the Supreme Court said, is worth it because of the tragedy that has been visited upon black voters over the history of their voting. And so it said, because it can rankle people so much, let us revisit this ever so often. Now, I do want to clarify one thing. I've often heard it said that number one, the whole of the Voting Rights Act had to be renewed. That is not the case. The Voting Rights Act remains the Voting Rights Act unless it is overturned by Congress itself. But it was that provision, the pre-clearance provision, and it is an act. I've heard some people point to a distinction between legislation and act, saying one is foundational and there, the other is not. Whether we call it legislation or act, it is still there. But there were sunset provisions, and with each reauthorization, the Congress would determine how long that sunset provision was to be, or how far away that sunset provision was to be in effect. And thus, when it was first passed, the Congress said, we want to revisit this in 7 years. And thus, in 1972, the debate came up, and the act was reauthorized for a 10-year period of time. That is the sunset provision or the preclearance. It was reauthorized again in 1982 for a 25-year period of time. It would have, the sun would have set in 2007, but George Bush signed it as Congress moved it forward in 2006. And it would otherwise be due to be set for reauthorization in 2032, except that that provision has now been declared unconstitutional. The point that many advocates of the Voting Rights Act have stressed is that it was 3 Republican presidents, President Nixon, Reagan, and Bush, who have signed the reauthorization. Now, let me say, it didn't just do this in a willy-nilly fashion. These were shown of hard, serious, ideologically driven debates. But in the final analysis, the congressional will was there to do it, and the presidents involved did sign on. Another thing that we will mention is this. We know, and I'll be sort of wrapping up as I get to this soon, we know that there have been several pieces of voting rights legislation advanced. The John Lewis Voting Rights Advancement Act and the Freedom to Vote Act. Both of these have been resisted by most, if not all, of the Republican contingents of the House and Senate. As you look back at the record, though, at least 15 to 16 of those senators, of those congresspersons, let me say, who indicate opposition now were among those who have always signed on to this legislation in a previous time. We're in a different space in time politically, and I think that drives so much of it. In 2013, Shelby versus Holder comes to us from Alabama. The county of Shelby County sued Eric Holder, the then Attorney General of the United States. It claimed that for southern states to be subject to the pre-clearance provision, while states outside of the South, who really had, they said, worse records of voter engagement by blacks than we do, for us to be subject while others are not is a denial of our 14th Amendment equal protection rights. We're simply not being treated equally. And they would say, not only is it just a fundamental denial of equal protection, they would also say that if you look at our records, we have an extraordinary number of black folks voting, many times more than other places, and surely much more so. In other words, our problems are no longer here. This should be declared unconstitutional, and Judge John Roberts does side with a 5-4 court. It's a different court composition then, with the majority, and writes the opinion that basically does say that the history of voting rights, oppression as it historically existed, no longer does exist. The case can no longer be made that these areas need to be treated differently, and thus it declared it a violation of equal protection. But Justice Roberts also said, as assigned to Congress, since you created this standard, if you revisit it and create a standard that will pass constitutional muster, then we will be able to have a more expansive Voting Rights Act. But this, of course, was a central provision because it was the first step in blocking issues. Some 8 years later, in the summer of 2021, we were in a far different environment. The election had by that time been held in 2020. The claims that there had been significant fraudulent activity in terms of voting ballots and ballots, dead people and things of that nature, and the whole call for greater integrity in voting was captivating the country, and of course, by that time, what we now term the big lie that the election had been stolen was not a lie in the minds of many others. It was an actionable truth that was proceeding. In the case of Brnovich versus the Democratic National Committee, the Democratic National Committee challenged a couple of things that the state of Arizona was doing. It said that we believe that people are harvesting ballots. That is, individuals are going around and collecting ballots and then bringing them to voting precincts to be counted. They said this harvesting is illegal. And then it said that there are some times when people quite unintentionally vote out of precinct. And when they vote out of precinct, we should not be able to approve those ballots. So those ballots can be eliminated. Well, as it turned out, and as the Democratic National Committee would show, there was a significant disparate impact on Black voters. These seemed to be targeted to Black voters. The harvesting was not really as it was set out to be. And the out of precinct voting was something that did hit particularly hard in African American communities. The Supreme Court upheld what Arizona was doing. Had these provisions been presented in the pre-clearance era, many have argued that it is quite likely that these never would have passed muster to go forward. But pre-clearance was no longer in the mix. Now, we still did have and still do have a section of the Voting Rights Act that does eliminate that. But the court said that it found those two efforts on the part of Arizona to be in line with voting integrity. And it said that even though there was a showing of disparate impact against Black voters, that there really was no showing that there was an intentional component to this, and that the disparate impact, though it was shown, was just a fact of the matter to note, and not something that should otherwise disqualify that. In an article that was subsequently written, and I put it here because the person who wrote this article, one of the co-writers, was Guy Uriel Charles. Guy Uriel Charles was a student at the University of Michigan in the 1990s. He was on the Journal of Race and Law. He's since had an extremely illustrious career as a law professor. He currently is at Harvard University as a law professor and the director of the Charles Hamilton Houston Institute. He and a co-laborer wrote an article that simply said, after the Brnovich vote, the court's voting right decision was worse than people think. And it's basically said the conservative majority opinion has declared that voter fraud and not race discrimination is a threat to the American system of representation. And as we know, whether it has come before the Supreme Court or the states themselves, voting fraud has not been found. In the period since the Supreme Court case of Holder, Congress has been, as I indicated, invited, if you will, in quotes, to revisit this position or this provision and to write it in such a way that it would pass constitutional scrutiny. There have been several efforts to do so, but mostly for procedural reasons. These have not moved forward until the events of 2020. Now, during this time, with the absence of the guardrails of Section 4 and 5, numerous states have begun to create, as we well know, barriers and protections. The Brennan Center for Law and Justice annually charts this, and there are other mechanisms that some will say that somewhere that in the 40s, at least 40 states or more have instituted or begun to explore ways of limiting, putting barriers in place to thwart voting engagement. And to get to where we are right now, following the events of 2020, the death of George Floyd, the heightened attention to the Black Lives Matter movement and the support which John R. Lewis was giving, Congressman Lewis was giving to this issue, even as he was quite close to death. There were two acts that were instituted, one of which would address the things that were struck down by Shelby versus Holder. In other words, let's fix the Voting Rights Act of 1965. The other of which would address the problems that were beginning to emerge in terms of the plethora of state legislations. These two acts, the John R. Lewis Voting Rights Act and what was at one time the Freedom to Vote Act, changed to the Freedom for the People Act of 2021, were brought forward, but they failed to muster the support to be brought to the floor. The term filibuster has been used to describe this 60 vote threshold in my era coming up, and for some of you others, you will recall the filibuster as a major means by which Southern senators, segregationists, blocked by means of talking for extraordinarily lengthy times civil rights legislation. In fact, the Civil Rights Act of 1964 that dealt with accommodations, employment, etc., took a year. There's a book written called The Longest Debate. Now those two bills at the start of 2022 have been combined into what is the Freedom to Vote John Lewis Voting Rights Advancement Act. This legislation would, among other things, standardize voting election laws across the country. It would significantly expand voting access by reversing the effects of state-level voting restrictions. It would restore key provisions of the Voting Rights Act of 1965 that had been struck down by Shelby County versus Holder. And one additional act, I had the ability to hear Congresswoman Joyce Beatty, who is the chair of the Congressional Black Caucus and a congresswoman representing the area of Columbus, Ohio, speak to this an evening this week. And she pointed out that the legislation that is now moving would also include a pre-clearance provision for every state in the country. In other words, if our ability to single out those who were bad actors in the era of segregation is deemed unconstitutional, we will touch everyone, and everyone will then have to do pre-clearance. Now, of course, we know the dynamics of Congress, the whole issue of who votes, the Democratic Party needing all of its persons on board to do various things. Lastly, I will just mention this. The Electoral Count Reform Act of 2022. The argument that was being brought forth by Attorney Eastman and others within the orbit of President Trump is that Mike Pence did have, as a vice president, the ability to block the counting of the votes, the ability to return it to the states. The Electoral Count Reform Act of 2022 builds upon an act that comes out of the Reconstruction era. It's called the Electoral Count Act of 1883, I believe it is, could be 87. It was in part generated because of the issues that came about in the aftermath of the Hayes versus Tilden election and at least one other election after that. But it specified that the role of the vice president was to administer the count. But the language in that was such that those who have spoken to and counseled President Trump said, well, it's not really clear, so we're going to make this argument. Because both Democrats and Republicans realize that that's a dangerous proposition. Because although you may be in power one set of years, you may be out of power in another. We can't invest so much in our states and in the vice president to just turn these back to the states. And so what the Electoral Count Act will do is two things. Number one, it specifies the language that says the role of the vice president in overseeing the election is purely ministerial. You cannot make decisions, you simply stamp it and move it forward. And the other thing that it would do is to raise from one person a threshold of 20 senators who would be needed if anyone should raise an objection about votes, and those objections would then trigger back. Now, one person can raise it and it can be voted upon. It's not been done in that way. Now it requires 20 people to raise it as a threshold proposition, and that's a significant higher one. Let me just stop with that, with this concluding thought. We, of course, have much work to do. Dr. King has reminded us that the progress that we have at any moment in time, as he put it, never rolls in on the wheels of inevitability. It comes through the tireless efforts and persistent work of men, we'll add women, willing to do, and those of however that designation might be, willing to be co-workers with God, because without this hard work and time itself becomes an ally to the forces of stagnation. So you're either moving forward or you're moving back, and we have to be the ones to make sure that inevitability comes only because we are inevitably doing what we should do. There's also been the concern about the kinds of things that the importance of the kinds of things that we are doing right now. We cannot just assume that history is on an inevitable course, a trajectory of human progress, that in time, if we just wait long enough, we'll be patient, we'll cure all of this. We're all familiar with the quote, "The price of freedom is eternal vigilance." While I understand that many of us would designate that as a term or as a quote that comes from Thomas Jefferson, it really is not. It's a term that comes from an Englishman, John Philip Curran, 1790. Or the statement in answer to a question. Benjamin Franklin, after the original Constitution was signed, was asked by a woman in Philadelphia, a female who was well positioned by virtue of her marriage and presence in Philadelphia society, to raise the question, but who could not participate in that constitutional convention. She raised the question, well, Mr. Franklin, do we have a monarchy or do we have a republic? And his famous reply, a republic if you can keep it. And we know lastly of the famous phrase that comes from Frederick Douglass. If there is no progress, if there is no struggle, there is no progress. Those who profess, and many of you could just stand up and quote this back to me. Those who profess to favor freedom and yet deprecate agitation are men who want crops without plowing the ground. They want rain without thunder and lightning. They want the ocean without the roar of mighty waters. Power concedes nothing without a demand. It never has and it never will. This is Frederick Douglass on the occasion of West Indian emancipation in August of 1857. And so we just simply come to the issue of the franchise, the right to vote. And the stewardship imperative, I want to stress it like that. There is an imperative on our part to be stewards of this franchise. Not just to occupy our space and time, but to be stewards of the franchise. The imperative of both knowledge and engagement. We haven't talked a lot about knowledge, but as has been demonstrated by the last several years, our knowledge of our constitutional and civic history is woefully low as a nation during these times. So we'll simply say we are stewards of this moment. We are the agents of America's transformation and our own salvation. And I have an image here that is taken from a set of young folks in Flint, Michigan. There is a young lady there, Angela Waters, who has been the driving force between an organization, a youth empowerment organization, One Love Global. They are investing themselves heavily at this moment in the right to vote. The young folk here holding up their pamphlets that are saying, Know your rights. This is your voting guide. These are the folks for whom we operate, for whom we count as the stewards over, the young folk of our country. And so with that, I will stop my comments and see if we might take questions. Ms. Faye, you can.
Am I on now? Yes, I can hear me. Okay. All right. Thank you, Professor Ronald Woods. As always, let me just say, I am always fascinated with how Professor Woods is able to really take us through a historical journey to help us understand how we got to where we are today. And I think that sometimes we forget or don't really quite understand what our vote really means. And so when he gives us information about laws and acts that happened in the past that changed what our vote means, that changed our ability and capacity to vote, laws that restrict, inhibit, and create privileges around voting in a historical context, it helps us really understand how significant that vote is. Because the people that we are voting for are the people who pass the laws and the acts that not only determine when, how, and where we can vote, but also other laws that impact our freedoms and the quality of the lives that we are able to live in this nation. And so, as Professor Woods indicated, we are at a critical moment in history in this country. And while we think about the horrendous murdering of Mr. Floyd that the nation and that the world saw happen on television, I think it concretized for many people the impact of racism in this nation. And I think it galvanized people from all the states in all of Europe and all of the world about how we do have to pay attention to the inhumanity that can be a result of racism. And so I don't think that we actually understand how our forefathers fought so hard so that we could vote, and how it almost seems almost insignificant, I think, to many people that what does it matter? Does my vote count? I'm a social worker. I've worked with a lot of low-income people, and their experience is it doesn't really matter who's in power. My life doesn't change. And I think that if there was a way we could galvanize, everybody in this nation to actually vote, then we as a people would have way more power than we have now. Because those people, believe it or not, work for us. And so if they are not behaving in Congress or in Lansing or in DC the way we want them to, then it is our responsibility to hold them accountable. And we're not doing that. And so I hope that Professor Woods' presentation today encourages you to vote in the primary, because the primary determines who runs, okay? So it means who you actually get to vote for in November. And so what struck me, one of the things that struck me, Professor Woods, about what you said was that the legislation can determine who is on the ballot separate from our ability to determine who is on the ballot. That is frightening. It is really frightening. Thank you. But we now have question and answers. So for those of you who are live streaming, there's also a Zoom piece for you. And so if you want to ask a question, please put it in the chat. Professor Woods is going to be answering the questions, so I'm going to be moving around, Okay, and so after we have the question and answers, if we have enough time, I have 4 questions that I'm posing for us as the audience to really think about, and maybe we can have some dialogue about, okay? So we're gonna start with the people who are here. Do you guys have any questions you'd like to ask Professor Woods? Anybody? Okay, I think Mr. McAfee has a question he would like to ask.
Wonderful presentation. We have coming up a primary August 2nd and a vote November 8th or so. What are the projected barriers we're going to encounter that are looking forward to, not really want, but we're going to encounter? Perhaps not in the primary, but certainly in the general election, that's going to try to keep us from the polls, such as wrong dates for the election, such as telling us not to go vote even though we're at the polls, and they're going to try to keep us from going inside of the building to vote, things like that.
Yes.
These are issues that have been talked about for a few years, several years, in fact, and we need to be prepared to overcome whatever those barriers are.
Thank you, thank you. Let me say, I will answer that to the extent of my knowledge, surely someone, perhaps from the League of Women Voters or other organizations could be more specific. The one thing that could arise is the presence of poll watchers. I do not know how that is those who represent a political party. It has always been baffling to me how coming out of the era of Reconstruction, we can't have people who do that, but the law does allow it. I'm not aware of how the likelihood of that is shaping up for those of us in Michigan. The other is the question of misinformation, of polls being closed or a different time for voting or even a different day. I don't have precise information on that. Let us all remain vigilant, knowing that these things are possibilities, that we could get a call saying, well, the vote was held last Friday or the vote is going to be on Wednesday. I just don't know those things, other than that they are always possibilities that require us to be vigilant in that regard. And again, I do apologize that I can't be more specific on that, but thank you.
Then do we have organizations that's going to help us to overcome those barriers? People stand outside of on the streets where I go vote, and they try to persuade us not to vote at that time, even though we're there. They may tell us the location is different than where we are. You know, I got a new card this year saying that because of the redistricting in Michigan, this is where I get to vote, and they went through like several different, not locations, but several different entities, like who my representative district is. District, I don't even know what it is, actually. 7, I think it is. Things like that. And they can basically try to tell us incorrect information. When that happens, who's going to be there to help us out?
Thank you. Some who have been election workers may be able to answer this in a somewhat better way than I. Number one, I do know that our city attorney will be very active in going around on election days and visiting various poll sites. I would say that should a specific question come up for any one of us in that regard, that an immediate inquiry to the Washtenaw County voter registration, someone help me with the formal name of Lawrence Kestenbaum, his formal title, county clerk, would be the thing to do. Organizations such as the Michigan ACLU, the NAACP, are often engaged in matters of this sort, but I don't have specific information to be able to give you on them. But Faye, perhaps you could.
Yeah, for those of you who registered for this presentation today, as part of that flyer, there were links for our local elections, the primary places where you vote based on your location. And so I encourage you to go back to the flyer and click on those links that provide you with information specific to your vote, where you vote, even who you're voting for in Washtenaw County, so that you get your voting location accurately. The League of Women Voters are planning to come to our October event. That is part of this series called The Great Migration, and you'll be hearing more about that. It'll be the first or second Saturday in October. But they're going to come and share with us some of the barriers to voting in the November election. So they thought that that would be a better time for them to come and share to help the voters really at the actual November election time.
Yes, ma'am.
I understand that they overturned Roe versus Wade. Can they overturn our right to vote as people of color?
Okay, thank you. And ma'am, my name is Ronald Woods, ma'am. Thank you. And by the they, I think you're referring to the Supreme Court of the United States. If the court were to rule as its norms would require that it rule, since the right to vote is constitutionally founded and established, the right to vote could never be overturned by the United States Supreme Court. The only thing that could change that would be if the 15th Amendment were itself retracted, overturned, etc., by vote. That would be the same vote as is required to bring it into being. That is 3/4 of the states and 2/3 of the Congress in that regard. So that cannot be overturned. What can be addressed would be matters such as Shelby versus Holder. That is state mechanisms or even congressional mechanisms that may be instituted to protect the right to vote that may be or that could be declared unconstitutional, as was Section 5 of the Voting Rights Act of 1965. But just as a pure matter to overturn the fundamental right to vote, no, that cannot be done by neither the Congress nor the Supreme Court of the country. Thank you, though, for that question.
And I think it's important that we remember we have three branches of government, and the executive branch is the president. The legislative branch is Congress, which is composed of the senators and the House of Representatives, and the judicial, which are the courts. And so when we elect a president, the president is the one who appoints people to the Supreme Court. And so some of us, this is my political moment, were concerned when our former president was elected because there was a possibility of his being able to select 2 or even 3 Supreme Court justices. And so now when I think about the revisions, I guess, of Roe versus Wade, that happened because the Supreme Court is now much more conservative than it's ever been in my lifetime. And so the people on the Supreme Court, even though they're appointed for life, they are influenced by the president that nominates them and the Congress that votes to approve them. And so, and again, another reason why voting is so important, because our vote determines every piece of the 3 parts of our government that operate. Okay, are there any other questions?
Faye, may I just elaborate a little bit on what Faye has said? Indeed, we do want to underscore for those who question why we vote, that every member of the United States Supreme Court was first nominated by someone who was voted into office by people who either voted or did not vote. Every member of the United States Supreme Court is someone who was confirmed by a United States senator who was voted upon by the people who voted for him or her, that is, as a senator, or by the people who did not. And I always add that there's no such thing as a neutral space for a voter. You either vote for, or by default, your vote goes to somebody, or your lack of vote goes to someone. Indeed, it is the case that every Supreme Court justice has been appointed by a president. It is not always the case, though, that a president will exert or inject himself into the dynamics of judicial politics or decision-making, as perhaps Mr. Trump has done. Again, there's often a sense that you were appointed by me and you will surely do as I would like you to do. That was, of course, an implicit observation or idea that he would advance. Few presidents operate in that manner. In fact, I don't know of any that I know of, at least in my conscious lifetime and by my understanding of history. And there are often times when Supreme Court justices will sometimes immediately and sometimes over time veer from the philosophical moorings of the president who may have appointed him or her. The most prominent is that of Justice Earl Warren, the justice who oversaw the case of Brown versus Board of Education and the many cases in the arena of productive rights and other things, the overturning of that established the Miranda rulings, what was often called the Warren Court. Many of you will recall that Earl Warren was a very solid conservative Republican at a time when to be a Republican did not necessarily mean to be conservative. He had been a Supreme Court, or he had been a governor of California. He had, during his governorship, overseen the internment of Japanese Americans in camps there in the state. An opening developed on the Supreme Court in the summer of 1953. The case of Brown versus the Board of Education, and President Eisenhower is at that time our president. The case of Brown versus the Board of Education would otherwise have been decided in the 1952-53 term. It was not. In part, the justices felt that they needed more argument, and this is somewhat unusual, but it can be done, that they needed more argument. And those who have looked at the court at that moment in time, that snapshot, said that if the case had been decided at that moment, it's not likely that there would have been a unanimous decision to overturn the Plessy decision, and there could have been a split decision in either way. As it happens, the Supreme Court justice at that point died, and the case of Brown versus the Board of Education was reset for the 53-54 year, and as we know, it was decided in May 17 of 1954. But during the summer, when the Supreme Court was in technical recess, the Chief Justice of the court died, leaving President Eisenhower, who leaned very solidly in a conservative Republican orientation, although as a military person, he had never declared his affiliation until the time of his having run for president. But President Eisenhower decided to appoint Justice Earl Warren. As we know, Justice Earl Warren comes to the court and begins to be the justice who lobbies significantly to overturn Plessy versus Ferguson, to essentially say to the states, and again, conservative or jurisprudence will often give deference to the states over the federal government. But he was arguing for a decision which would have overturned the ability of the state of Kansas and Delaware, South Carolina, Virginia, and the District of Columbia to determine how it wanted to order education. Justice Warren did lobby successfully until every one of his Supreme Court justice or associate justices indicated that they would vote. And those who have looked at this said that Justice Warren had a kind of pencil holder cup. And every time he would get another justice who would be lined up to overturn Plessy, he would put a pencil in that cup. And then we know that the decision of Brown versus the Board of Education was read, and again, he felt that that it was important to have that as a unanimous decision because of what it meant to the country, to break the back of segregation, et cetera. And on the morning of May 17th, he does begin to read the case to read the decision himself. Justice, it is said that in the aftermath, Eisenhower was quite upset with Justice Warren, feeling that he had gone against what his assumptions would have been about how he would vote. But Justice Warren goes on to oversee perhaps the most liberal, and I will say positively liberal, judicial decisions that were so critical to so many things in the course of our country. So I just simply say that. Now, there have been others. Justice Roberts himself has sided with the Obamacare, a couple of Obamacare decisions that have upset considerably conservatives because he veered from the line of the person who might have appointed him, George Bush. Thank you for allowing me, Faye, that overly long explanation on that.
That's totally okay, but for those of you who don't know the history the way Professor Woods does, Plessy versus Ferguson is the Supreme Court decision that ruled separate but was equal, and Brown versus Board of Education allowed us to have integration.
I wanted to add to what Faye said 5 minutes ago, maybe. I voted absentee ballot this year. If you live in the Ann Arbor area, I got an email yesterday saying that they had received my ballot, validated my signature, and it's going to be counted. Oh, okay. I'm sorry. I thought I was. I voted absentee ballot, turned in my ballot Wednesday, and I got an email yesterday saying that the ballot had been received and the signature had been validated and it will be counted. That's one of the nice, comforting things to me about voting in Ann Arbor, and I don't know what other jurisdictions have that. But we really do know that the ballot has gone in at that point. And I know it happened in the November election 2 years ago. We got such a thing. I wanted to also go back to the question about can our right to vote be denied? If you look at what's happening in Texas and in Georgia, as an example, the right to vote is not being denied, but it's been made exceptionally hard to execute. Texas putting one voting location in the big county in Houston, Harrison, and in Harris County, and in Dallas County, things like that, one place to vote. And Georgia saying you can't bring a bottle of water, no matter how long the line is, to a person standing in line. It's not denying us the right to vote, but it's, in effect, doing such. So those are the type.
Right.
barriers I was talking about that's getting tossed in front of us.
That's right, and that's what that renewed Voting Rights Act will be all about. Thank you. No, you're absolutely right. Absolutely on that.
We have a question from someone who's online, and I'm sorry, I have to keep walking in front of the camera, but I can't get it any other way. Okay. The question is, I have heard that the words relating to, quote, all men being created equally, unquote, etc., as written in the U.S. Constitution, were not meant to include African Americans. Would you share your understanding regarding that interpretation?
Yes,
That's
sir.
from Ms.
Yes, ma'am.
And that's from Ms. Gloria Edwards.
Thank you, Ms. Edwards. I appreciate that. Hope you are well, too. Now, indeed, the phrase itself does come from the Declaration of Independence. That's not a challenge, though. That's where it says we hold these truths to be self-evident, isn't it? That all men are created equal and endowed by their Creator with certain unalienable rights. Excuse me. But that spirit is embodied in the preamble to the United States Constitution, where it says, we the people of the United States, in order to form a more perfect union, establish, do hereby ordain this Constitution. That spirit is a very important spirit to discuss, not lengthy matters. The orientation that Dr. King and many other advocates of rights going up to that point in time would take is that the absence of the technical use of women or of blacks from those documents does not at all preclude the fact that these documents pertain to us. As Dr. King would say it, when the architects of our documents placed these before us, they were creating a legacy to which every American was heir. And so I think the point that Ms. Edwards raises is an important point for exchange. What many have argued, going back to civil rights advocates and others out of the late 18th and throughout the 19th century, is that you cannot exclude from the language those who are part of the populace and the citizenry, small c, of the country. That once an idea is exposed, it applies to everyone within the space of history that it would be appropriate to. Now, the argument, though, has been advanced that we read this very technically. It says all men, and so all of these other things. But I think the course of history has shown, and I would surely encourage all of us to continue to say, that once once freedom is exposed and released, you cannot bottle it up into particular terms and persons and all. But it's an extremely good question, Ms. Edwards. I appreciate that. Thank you. Thank you.
Okay, we now have, does anyone have any other questions while our tech person puts the questions that we'd like for everyone to think about on the screen? And Nisha will check to see if we have any more questions from those who are watching online or listening online. Do any audience participants have any questions they'd like to ask now? Okay, all righty. So here are questions I'd like for us all to think about. And thinking about Professor Woods' presentation today and the history that he has shared with us, how do voting rights reflect who is considered to be an American at different points in this country's history? So how do voting rights reflect who is considered to be an American at different points in the history of our country? Thoughts? Okay. It is more difficult for certain groups of people to vote. What effect does that have on how representative the government really is? These are things for you to think about. And then, what should happen when it is apparent that voting restrictions impact some groups more than others? What might happen if such disparities go unaddressed? And the last question for thinking and thought is anti-lynching activist Ida B. Wells said, "With no sacredness of the ballot, there can be no sacredness of human life itself." What do we think this quote reveals about the importance of the right to vote? And Professor Woods asked me where this quote came from, so I looked it up. And Ida B. Wells wrote this quote in a pamphlet in 1910 entitled, "How Enfranchisement Stops Lynching." And the full quote is, and I think this is what we today should think about, because I think it impacts kind of where we are today. "For if the strong can take a weak man's ballot when it suits his purpose to do so, he will also take his life." And I think for that kind of wisdom to have existed in 1910, that's so relevant to where we are today, is really food for thought. So I'd like to thank you all for participating. I thank you all for listening, and I especially thank Professor Woods for his wonderful presentation again.
No, thank you, thank you. Thank you, everybody. This is good. Thank you to our listening audience, too.
Right. Is that still on? I just want to also officially say thank you to Professor Woods for agreeing to be our speaker and for sharing his expertise and wealth of knowledge with us today. We also want to thank all of you for your attendance, participation, and support. We want to thank Nisha Revere for her help and assistance today. And we ask that you please mark your calendars and join us on the 8th of October, as our next topic will be the Great Migrations. There will be, that will follow with our Fun Day that will also be in October. Our last topic in this series will be the history of protest. We hope that you will keep an eye out for these event dates and join us as we continue to explore and widen our knowledge. I'm going to close with just a couple of quotes from Martin Luther King. "We must have our freedom now. We must have the right to vote. We must have equal protection of the law. And make a career of humanity. Commit yourself to the noble struggle for equal rights. You will make a greater person of yourself, a greater nation of your country, and a finer world to live in." Again, we thank you, Bethel, and for all of you who are here and participated, and again, for you, Dr. Professor Woods. All right.